Pinar Akman, welcome to Digital Markets Research Hub. I'm grateful for the opportunity to discuss some issues with you, and given your expertise, we will be discussing 102 and its 2.0 version, so to say, the Digital Markets Act, and the cascade of issues associated with these two areas of competition law in the broader sense, competition policy. And you've published several remarkable pieces which somehow reflect the development of the field. Your papers and your monograph on Article 102 epitomizing the more economic approach and criticizing the form-based vision have channeled the development in the field in many respects. Many people agree, many people disagree, but it reflects with the substance of the papers, I mean. Now you published a new piece in Oxford Journal of Legal Studies, given it, the venue gives it great visibility in terms of, you feed the discussion not within the clusters of competition policy specialists, but broader legal community as well. So I wanted to use this opportunity and to start this conversation with asking you to highlight the key messages of this latest paper.
Thank you, Alyssa, and thank you for having me on your series. So yeah, where do I start? It's been a long journey with me, and Article 102 this is also the subject matter of my PhD, which I started 20 years ago now, actually. So in the latest article I published on Article 102, which is essentially a critical inquiry into the concept of abuse, as I call it, the main problem that the paper addresses is that the tool of Article 102 as a legal instrument is a very powerful tool. It can, reconstruct and construct business methods and models for powerful undertakings. It can impose severe sanctions, which can be quasi-criminal. So the scope of application is vast, and it's a very powerful tool in the hands of competition authorities. But if we look at the substance of the concept of abuse, which lies at the heart of this prohibition found in Article 102, the concept itself is not very clear, and therefore the legal requirements of establishing when a given practice adopted by an undertaking in a dominant position are also unclear. So this is the motivation behind the paper, because this is suboptimal for a number of reasons. You can't really, in a system operating on the basis of rule of law, have such a powerful tool in your hands where its application is so potentially unclear, because in terms of legal certainty, the undertaking subject to the law do not necessarily know before they engage in an act which side of the law they stand on. And in order to inform those undertakings ex ante, before they engage in the practice, which side of the law they will find themselves on if they engage in that practice, the legal requirements of abuse, in other words, what are the constituent elements of abuse, have to be clear beforehand. And this is the motivation behind the paper. So what I try to do is to go through the case law of the Court of Justice of the European Union in particular, try to, I guess, expose the trajectory that case law followed over the last many years, but focusing specifically on the last decade, to see whether we can now, where the case law has come to, work out the legal requirements of establishing abuse. So what are the constituent elements of abuse if we look at the case law of the Court of Justice of the European Union? The Court of Justice is, of course, the final arbiter of EU law. So when especially you have a piece of legislation that's so unclear, how the court interprets that piece of legislation becomes of crucial importance in terms of setting out what the legal requirements and the constituent elements of abuse are. And I try to explain in the paper that, especially if you look at the 12 to 13 years of jurisprudence from the Court of Justice, we can more or less work out a framework which provides more legal certainty, I think, and more method than was the case previously with the case law in terms of the constituent elements of abuse. And that's what the paper does in a nutshell.
And you start with refer to the object-effect dichotomy or lack thereof in 102. Can you highlight and explain the pathway?
Sure. So as we all know, in Article 101 of the Treaty on the Function of the European Union, we have an explicit distinction between the object and the effect of a practice, which may prevent and distort competition. And that distinction between the object of a conduct, which might have restrictive, essentially, implications for competition law, or the effect of a conduct which will have restrictive effects on competition, is enshrined in the treaty itself. Now, if you read Article 102, it doesn't make any reference to the object or effect of a practice. It just prohibits abuse. And of course, we have to bear in mind that the drafters of these two provisions are the same group of people who drafted the treaties of Rome. And so this is sort of the first starting point, really. But in practice, arguments have been made by commentators to suggest that there is also an object-effect dichotomy in the context of Article 102 as well, similar to the dichotomy in Article 101. So if we take that argument at face value, and in fact, or indeed, if we take that argument in the context within which we have Articles 101 and 102 together as part of the EU competition law framework, then I think the logical conclusion of that argument, that there is an object and effect dichotomy within 102 as well, would be that there are then certain practices which are examples of unilateral conduct, so adopted by undertakings unilaterally based on a unilateral business decision, not within collusion with others, which can also be found to violate EU competition law without a need to consider even the potential effects of such conduct, because that is how the object and effect dichotomy works within the sphere of Article 101. So within Article 101, if the conduct falls within the types of conduct which we characterize as by object violations, then there is no assessment of the effects of that practice on the market, on competition, on consumers. But I think also most importantly, you cannot save a by-object violation through a demonstration of the absence of effects. And I think this is where this idea that there is a dichotomy within Article 102 as well falls apart. Because I think it's especially clear in the recent case law of the Court of Justice that even for those types of conduct which are deemed with a high degree of suspicion, let's say exclusivity arrangements or loyalty rebates, there is still the possibility to show an absence of effects in order to prevent a finding of a violation of Article 102. So this is at least my reading of the recent case law, and in that group of recent case law, it specifically put Intel, of course, then Unilever, and the SAN or NL case of the Court of Justice. I mean, at a higher level, of course, this distinction also means that where you do have an object category, the approach of the authority can be and will almost certainly be more formalistic than where the authority is required to engage in assessment of the effects of a practice. So I think within Article 101, we have that formalistic element of object violations. And I think within 101, it's also appropriate to have that category of restrictions, because when it comes to collusive conduct, when it comes to cartels, economic experience and, decades of research, experience, evidence tell us that there are certain types of practices which, when adopted by a group of undertakings who come to an understanding to act in that way, will almost always cause harmful effects on competition. And that's why we prohibit them by object. Now, let's also not forget that underlying those presumptively restrictive practices that are restricted by object is also the assumption that we know based on economic evidence and expertise that they will have effects. So even that by object category is really not so devoid of some effects, an angle, let's say. But the key distinction when it comes to the legal application of these rules is that in the context of Article 102, first of all, it's enshrined in the treaty. The Court of Justice can't read it out, even if it's, approach to competition rules and their application changes. It's in the treaty. And what that means for the context of 101 is that if the practice falls within this category of by-object violations, the commission or the authority will not need to engage in an effects analysis to demonstrate a violation of the law. But what it also means is that the parties or the undertaking subject to, let's say, a cartel investigation, if it's a by-object violation, cannot also bring forth evidence to say that, oh, but our cartel didn't have any anti-competitive effects and therefore it shouldn't be in violation of the law. That's just not possible within a by-object framework, because if you could disprove a finding of by-object violations by a demonstration of the absence of effects, you would just annihilate the by-object framework. You would no longer have a by-object framework. So what I'm trying to argue and saying in this paper is that we don't have a similar categorization in the context of 102, because even if we do have circumstances such as this, latest idea of naked restrictions, let's say, even if we may have some circumstances in which there is almost a presumption of this conduct potentially being an abuse, it's still not the same. In fact, it's not still similar to what we have under Article 101 as a by-object violation, because, amongst other reasons, the possibility to disprove that potential finding by a demonstration of the absence of effects is essentially possible under Article 102, which is not possible under Article 101. So that's sort of a long answer to a short question.
But from normative perspective, we hear some people, so the spectrum of views is quite wide for obvious reasons, but we have some people saying that the standard introduced or discovered or rediscovered or created by the Court of Justice in this latest wave of judgment is very high for the Commission to meet, and then we goes to the variety goes to the other polar side, where we say, well, the stakes are so high and it's so uncertain by very nature. We look exposed into something where which happened some time ago, etc. So where would you categorize or position your normative views or the views which underpin your argumentation?
That's a very difficult question. It's a tricky question, because in this paper, I specifically note that I'm not making any normative arguments in this OJLS paper, anyway, the latest paper, because that paper is about trying to set out as clearly as possible where the case law currently stands and what we can derive from the case law in terms of trying to come up with something that looks like a framework, which would provide sort of hopefully more certainty in terms of where the law is when it comes to, what's an abuse under Article 102. In terms of my normative stand, I'd have to, I think, write probably on that before I can speak about that. But I mean, in some ways, I've written about this in my earlier pieces. So my book, for example, the concept, my book also looked at the book called The Concept of Abuse in EU Competition Law. It looked at trying to establish a framework which would sort of make sense from a legal and economic point of view. And in my book, I had argued that to have an abuse, and that was a sort of normative argument, you must have three criteria, one of which you must always have exclusion, you must always have exploitation, and you must be able to show that essentially the practice in question is not overwhelmingly efficient to the extent that the efficiencies actually outweigh all of the previous effects. So that's the normative, and I think my normative position on that still stands. That's normative position on abuse that I have. You have to have exclusion, you have to have exploitation, and it has to be the case that there aren't trivial efficiencies. I think your question relates more to perhaps burden of proof, and perhaps it's easier to answer the question, whether I think the Court of Justice's, recent approach to abuse of dominance makes it unduly burdensome to prove an abuse. I think that's easier to answer than, what's my normative position on abuse. I don't think it makes it unduly burdensome to prove an abuse. The Commission has an appeals record, which probably no other, competition authority in the world has, in terms of how successful it has been on the appeals against its decisions. I mean, I think until recently, it had never lost an appeal when it came to Article 102. And I'm not sure that's necessarily a healthy sign. Recently, the Commission have lost a couple of appeals, important ones, of course. But if we actually look at some of those cases and the reasons for which it lost an appeal, putting aside, let's say, the substantive part of Intel, a lot of it has actually had to do with procedure. And if you read those judgments and what's happened in the Commission decisions, and why the decision is being quashed with regard to, let's say, procedure, I mean, I was personally very surprised to see that that sort of procedural defects could be taking place at the investigation stage at such a highly respected and well-regarded authority. So, of course, fine, the Commission has had a few knockbacks at the Court of Justice. I think there were good reasons beyond the substantive for those knockbacks. And I mean, I'm hoping, the recent move towards adopting guidelines and so on is not really a reaction to the fact that they lost a couple of cases. I think losing a couple of cases in over 50 years is really not a record that would suggest that, it's become unduly burdensome to enforce the law. And whether it would make the law too difficult to enforce in terms of any substantive changes, I don't think so, because I don't think the court has necessarily moved that far in terms of the approach. Anyway, I mean, we don't have a Chicago approach. The court is not Chicagoan. It's nowhere close, really, because like I argue in the paper, we seem to have this now hybrid era in the case law where we have all these modern economic principles sort of being integrated into the case law to some extent, but this is building on top of a case law that's decades old. And in those many, many, many decades, the approach was quite formalistic, quite European, unique in that sense. And many of those propositions and elements, like the concept of competition on the merits or special responsibility or, freedom to compete and so on, they haven't really left. So they're still there, but they're almost operating in parallel to these new, more economic principles. So I'm assuming those traditional principles would still mean that it's never going to be as difficult, let's say, in the EU to establish an Article 102 violation as it might be, let's say, in the States, assuming, they have a Chicago approach, although obviously that's changing too. So I don't think it's become unduly burdensome, and the Commission's track record would suggest that it hasn't become unduly burdensome because the Commission is still very much enforcing Article 102 and by and large not being overturned on appeal.
Thank you very much, Pinar. And looking at the components which are being operationalized by the parties and by the court, we see that one of the most impactful, most decisive role plays the as efficient competitor. And then we have three dots there, because there are several things which refer to as a concept, as a very idea, as a test. Can you elucidate on this? What's the interplay? What is the stake there?
Sure, thank you. Yes, I think the efficient competitor standard has become the lodestar in this sort of recent flurry of cases where the Court of Justice has adopted a more economic approach. And I think one issue there is that relatively often the concept of the standard, this efficient competitor standard, which is essentially a principle, gets confused with this efficient competitor test. So the standard was advocated by Richard Posner in his book, where he put forward this standard as essentially a principle with which, at a high level, gauge whether a practice by a monopolist was potentially pro or anti-competitive. And the idea there is that we don't necessarily want even dominant firms to hold a price umbrella over their rivals. So we want companies in a market to operate as efficiently as possible. We want to encourage efficiency, even if we have essentially a dominant firm on the market. And the standard is therefore about establishing whether competitors that are as efficient or more efficient than the dominant firm would be able to basically survive on the market when this practice adopted by the dominant firm is imposed on them. In essence, what the standard is checking really is whether the dominant firm itself could withstand its own practice where it's subjected to its own conduct. And therefore, I think the standard makes intuitive sense if we believe, in markets operating more efficiently rather than, less efficiently. And that's the principle. And I think that's what guides, or at least underlies, some of the recent case law of the Court of Justice, that if undertakings leave a market because they're not as good as the dominant firm, because they're not as efficient, they don't deliver the products and services which consumers want at better prices or at a wider range of choice, and they're excluded from the market as a result of the practice of the dominant firm, then this in itself is not anti-competitive. This is a natural aspect of competition that, the better ones stay and the less good ones leave the market. And I see this efficient competitor standard principle as essentially explaining that. This efficient competitor test, on the other hand, is a technical test which competition authorities use to see whether the effective price that a competitor would have to match, let's say in case of rebates, to be able to steal those customers away from the dominant firm. These customers are being offered very advantageous rebates by the dominant firm, and a competitor needs to be able to, take them away, steal them away from the dominant firm if it's going to compete with it. So in that case, this efficient competitor test would ask whether the effective price that that competitor would have to charge is to steal the customers away is above or below cost. And that ultimately almost boils down to a predatory pricing test, which we saw, I think, in the Commission's guidance, where essentially the whole thing seemed to boil down to a predatory pricing test. And I wrote about the guidance in an article in the Modern Law Review when the guidance came out, where I said basically the test has become that of whether the price is predatory or not. Now, that technical test, because it's so intimately related to the existence of a price, because it's essentially asking whether the effective price that they have to pay, the competitor has to pay to compete with the dominant firm, is essentially above or below price. It requires there to be a price. So in types of practices that are potentially abusive but which don't involve a price, this efficient competitor test is therefore not necessarily useful. And I think this has led some commentators to argue that therefore, for example, the Intel ruling is only relevant in pricing cases, because all these cases, the recent cases, have been about pricing, and therefore the relevance of this efficient competitor, well, there people confuse the standard with the test, is only for those abuse cases where the conduct in question is a price-based conduct. And this is where it all gets a bit muddled up, because this efficient competitor standard can apply equally to non-pricing practices and pricing practices, because it's as a matter of principle asking whether essentially the dominant firm itself can withstand its own practice if it was subjected to it on this market. You don't need to have a price element there. As efficient competitor test, on the other hand, by its nature, necessitates there to be a price for there to be a calculation of whether the effective price is above or below cost. So as efficient competitor, the efficient competitor test may only be applicable in cases that concern pricing, but this efficient competitor standard essentially is applicable across the board. But if you confuse the two, then we'll end up with the conclusion that this efficient competitor framework, let's say, is only applicable to pricing cases, which is not the case if you read the case law of the Court of Justice. I don't know if that makes sense.
But which is still a reasonable normative position, yeah. So basically, that adds to the confusion, yeah, because people might disagree with the substance of the very idea of as efficient competitor test standard, and thus it creates another layer.
Yes,
of
indeed. Yes, yeah.
Okay, so you have highlighted quite a few points about Intel. Is there anything specific about this case which you have dedicated quite a lot of time in your paper, which you want to add?
So Intel I see as a turning point, really, but I mean, Intel itself is not an example of clarity by any measure. It's not very clear. And that's why Intel also led to a lot of debate after it came out in terms of commentators disagreeing with each other in relation to what Intel actually meant, you know, whether it was just a procedural point of view, whether it was just instituting this principle that the Commission must now apply this efficient competitor test standard, whatever it might be, only in pricing cases, or whether it had more broad, whether it had broader application. I think Intel definitely marks a turning point, because things really seem to start to change after Intel. And the real impact of Intel is perhaps perceived better in the judgments that come after Intel. But yeah, I mean, two things to note about Intel is that it's not really a judgment that's, you know, an example of clarity. It would have been, you know, much better if the Court of Justice spelled certain things out perhaps more clearly in Intel, but it's a very constrained ruling. When you read it, the court really doesn't go, you know, a step above what it has to say to resolve that particular issue. Another thing to say about Intel is that I think the later rulings did clarify that Intel was not just making a procedural point, and Intel was not just about pricing conduct in terms of the principles which it sort of espoused. I think the principles from Intel have general applicability, as demonstrated by many of the rulings that came after. Now, Intel is, of course, itself not yet over. And I think Intel has left us with a bit of a mess around naked restrictions. And that is going to be something that I'm assuming is going to make an appearance in the guidelines.
Let us move to guidelines. We see it as not a parallel process. It obviously depends a lot on the latest cases. And how do you see the evolution of the enforcer thinking in terms of trying to systematize the jurisprudence? We know that we came in 2008, the guidance paper made a paradigmatic shift in the following adjudicating processes, and maybe paved the way to a more economic approach in the judiciary. Some people say that it's too late to turn the transport, because it's the cases have been already delivered by the Court of Justice, and the interpretation has been provided. So others say that yet it's an important juristic toolkit which would allow to refine and underpin and mature some issues which appear to be problematic from the perspective of Digicom. How do you see this process and where it will lead us in your view?
Yeah, this is a very important and difficult question. So I wrote in that paper on the guidance, which was published in the Modern Law Review, I think around 2009 or 10, that the guidance read like a compromise document, and it wasn't probably going to bring about a lot more certainty than there was beforehand. So at that time, my reading of the guidance was perhaps less positive than some other commentators, and I didn't see the guidance necessarily making a dramatic change in things to come, because it read like a compromise document in terms of also its principles and how it was to operate. And in some ways, the announcement of the guidelines has vindicated that view of mine, because clearly the Commission has not been happy with the guidance either, perhaps, for various other reasons too, but it wasn't necessarily a tool that was going to bring about, at least in my reading, a lot more certainty specifically. And if we look at what came after the guidance in terms of the decisional practice, I think this is one of the perhaps more interesting observations I make in the article. We were all expecting the Commission to push for this more economic approach and the effects-based approach in its decisional practice. And the question mark was over whether the court was going to follow the Commission's lead, whether the court was going to buy into the more economic approach. But what we see in practice, I think, is that the positions have changed basically like this. So where the Court of Justice has adopted a, let's say, more economic approach, I know that's a loaded term, but let's say more economic approach in the sort of simplest sense of that word, without the baggage, let's say perhaps an economic approach or an effects-based approach, it has actually been on the occasions where the Court of Justice has reversed the Commission, where the Court of Justice has annulled Commission decisions, that we have moved towards a more effects-based approach. So first, I think, observation is that the Commission's decisional practice did not necessarily bring to life a more economic approach or an effects-based approach, as some were expecting, I think, at the time the guidance was adopted. The guidance was, of course, guidance on purpose, not guidelines. And I think that's also a sign of the underlying compromise. And now we have the announcement that the next piece of document is going to be guidelines. And I think this announcement came at a very interesting time, and I'm not really quite sure how to interpret this timing of this document. So if we look at the last, let's say, 15 years since the guidance came out, the Commission has become, I think, sort of has fallen out of love, at least a little bit, with the more economic and effects-based approach. I think we can see that quite clearly when we read, the package of documents that was published with the announcement that there will be guidelines. And the Commission explicitly says that this has made it too difficult to enforce. That implies that the next stage of this evolution, at least for the Commission's perspective, has to now make it easier to enforce, which means we need to sort of turn down the more economic approach as we have it from the Court of Justice rulings from the last, let's say, 10 years or so. So this means that the Commission is likely taking a step back. But this is coming at a time where the court has gone quite far, I think, in the evolution of the court's case law, in sort of integrating these various economic principles into the case law time and time again. So why the Commission has decided to issue these guidelines, and the documents from the Commission say that the Commission is going to issue guidelines because it wants to increase legal certainty in this area by essentially codifying the case law. But, you know, knowing this context in which these different institutions have been moving and the directions they've been moving in, so I'm finding it hard to understand why the timing is now. Because if the Commission now codifies the Court of Justice case law, while remaining loyal to the sort of spirit of that case law as well, what will be codified will be a fairly economic approach. But everything else that we read suggests that the Commission is not so in favor of that economic approach anymore. So why we're having guidelines now, I can't really obviously answer that question, and that leaves me curious and without an easy answer. I have some theories, but I'm not going to go into those now because it wouldn't be appropriate. So it's going to be very interesting, therefore, to see what will actually be in the guidelines and how they conform or not to the case law, particularly the recent case law of the Court of Justice.
That would be really interesting. I wanted to ask your opinion as an academic about this process. Do you see this evolution, or do you see this conflict between, let's put it in the vocabulary of more form-based approach or law-based approach, legal form, because there is an economic form, a reference to economic versus effect-based approach, as a kind of evolutionary process, or as a kind of, we have two mature ideological visions about the level of enforcer's discretion and intervention into the market processes. One is more hands-off approach, another is more reliance on more interventionist vision. And we have this kind of almost pendulous relationship between the two quite well articulated positions existing in back in antiquity with some obviously refinement and amelioration in each phase of their almost antagonistic relationship. Do you think we are moving somehow continuously upward? And I'm asking it in the context of election and the next Commission mandate, how feasible, how plausible it is in your view that the Commission ultimately will change its approach, and how responsive the courts are and how quickly they evolve, and if you talk about evolutionary approach, or how they change their normative position. So more kind of theoretical or hypothetical pub style philosophy rather than hypothesizing about the reasons why the guidelines are being drafted in this current moment.
That's it's a very good observation, and it's a difficult question, and it's a long question with lots of questions inside. So let me see if I can unpack that maybe. I think your first observation is actually very interesting, whether the form-based approach and effects-based approach is necessarily, you know, one comes after the other in terms of an evolution, or whether they're just two, you know, equally strong positions, both with different underpinnings. Perhaps you need to be an economist to be able to answer the question whether they're equally strong. The way I see it, the effects-based approach, an effects-based approach is preferable over a form-based approach because you are more likely to get it right with an effects-based approach, at least in the context of unilateral conduct. And there are pitfalls of the form-based approach, which you won't necessarily have with the effects-based approach. So I'm currently working on my next monograph on actually not abuse of dominance, vertical restraints in e-commerce. And I'm reading at the moment a lot of the economics literature on vertical restraints. And one thing that comes out quite clearly from that literature is that a form-based approach to vertical restraints really doesn't make sense, because from an economic point of view, an RPM, let's say resale price maintenance agreement, can have a very similar effect to, let's say, a most favored nation clause under certain circumstances. But if the law is categorized along the form of the practice, then it's going to prohibit RPM, but not necessarily prohibit MFN, whereas the outcome on competition, on prices, on consumers is actually exactly the same. So to me, this is the most important problem with a form-based approach, that it's not necessarily going to be in tune to the potential effects of that practice on consumers, on prices, on competition, on markets. And it's going to be driven purely by the form of the conduct. So that's what I mean by the form of the conduct. So if it's RPM, it's prohibited. If it's not RPM, it's not prohibited. Type distinction. I don't know. If it's an exclusivity rebate, it's prohibited. Doesn't matter whether it has these effects or not. But if it's some other type of rebate, then that's okay, even though that other type of rebate may also have the same effect. So the possibility of making these errors, I think, is higher with form-based approaches than with effects-based approaches. And I think ultimately what we are interested in is the effects on competition. I mean, let's go back to what we said about even the by object violations. We prohibit them by object, those, one-on-one violations, because experience and economics tells us they will have those effects. It's just the chances of them having those effects are so high that in an individual case, we don't have to go through the rigmarole of establishing the effects. So I think even an object approach, which is a formalistic approach, is ultimately driven by the potential for anti-competitive effects. In the context of the guidelines, how likely is the Commission to change its approach? I mean, the Commission clearly was never very fond of the guidance, because I think the guidance was only referred to in any Commission decision once or maybe twice. Like, they never actually made use of the guidance in the actual decisional practice. And therefore, I think that's the perhaps rationale for the Commission to act, to perhaps clarify its own approach, which presumably was never really so in line or very in line or fully in line with the guidance anyway. So from the Commission's point of view, perhaps this is what the Commission is going to do. But in some sense, for that exercise, you would prefer a guidance than guidelines, because when this document is called guidelines, then this is going to be, let's say, in the same category as the guidelines on vertical restraints, which I think is used by businesses essentially as a rule book, whereas the guidance was almost more internal, not internal, but almost more individual for the Commission to say, these are our priorities, this is what we will do. So when it comes to guidelines, I think it's going to take on a different life, what the Commission is going to do in comparison to what it did with the guidance. And I think it's going to perhaps also have more impact in terms of the businesses, planning their practices and so on. It's going to be similar, as I say, in terms of planning purposes to the guidelines on vertical restraints. I assume, obviously, this is going to apply to a smaller group of undertakings, those with market power. What I don't quite know is what's going to happen if the guidelines contain principles that are not in line with the case law. And I think that's where the crux of the matter will lie. There is a debate among commentators whether guidelines can go against case law. I think the Commission thinks that they can go beyond the case law and they can set out principles that are not necessarily the same ones as in the case law. Others say that that's not possible. And I think this might be a good test case where we're going to see, A, whether the guidelines will go against this at least recent, wave of case law. And if B, if that does happen, will this, be brought before the court at some point? And how will the court then decide on that?
Thank you very much, Pinar. Let's move to the DMA.
Sure.
We can see it as different people have different opinions. What is your opinion? I know I'm mindful of time. What is your opinion about the DMA?
So I have written about the DMA. I wrote an article in the European Law Review that came out in 2022. We had the draft of the DMA at the time. I guess I have mixed feelings about the DMA. Perhaps I should start by saying that I'm not against regulation. I think certain aspects of digital markets do require regulation, and for various reasons. Whether the DMA is the right type of regulation, I'm not so sure. And in fact, I think it probably isn't. So in principle, I'm not against regulation, but I don't think in practice the DMA is the right type of regulation to deal with some of the issues in digital markets, which do require regulation. So I, for example, would prefer the UK approach here, although we don't have quite the minute details of that yet. In principle, I think an approach where you have a set of obligations that are tailored to an individual undertaking may work more effectively in getting you the results you want than having different lists of practices that apply in a blanket fashion to very different undertakings in very different markets with very different business models. And I think there are issues about sort of conceptual clarity in terms of the goals of the DMA. We have this chimera of contestability and fairness, but it's not so clear, whether contestability really can be achieved by many of these objectives. It seems to me to be more geared towards trying to ensure some fairness between these gatekeepers and their trading partners. But that's almost a micro approach to the issues rather than a macro approach. I think at the macro level, it really should be about contestability. There's also the question whether the DMA is about setting rules for markets which is related to the earlier point that I've already tipped, or whether it's a tool that is to prevent tipping. Because if it is the latter, if it is supposed to be a tool that should prevent markets from tipping, then I think would need to look quite differently. Their contestability would be more important, and then you would need rules that are trying to foresee where the bottlenecks will be and prevent those bottlenecks from happening. Whereas the DMA, as it is, I think, is more about markets that have really tipped, and therefore becomes more about ensuring or striking some level of fairness between the business partners of these gatekeepers against the gatekeepers. But will that create more competition? Will that make the markets actually more open if it's about essentially the distribution of rents between, let's say, app developers and app stores? How will this actually, at which level of competition will this generate more competition? I'm not sure it's going to make markets necessarily more contestable. And again, if we look at the obligations, I wrote in that piece in the European Law Review that many of these are not self-executing. They can't be self-executing given the content of these obligations. And I predicted that there will be a lot of litigation based on these. And we already see, the first tranche of that litigation. And just the fact that the Commission has already, opened investigations tells us that they probably weren't self-executing, because if they were self-executing, you shouldn't really need to be opening an investigation as soon as the legislation comes into force. And a lot of them are not self-executing because they've been drafted based on competition law investigations, essentially. Potential violations or violations in competition law investigations have been codified into ex-ante rules in the DMA. And of course, one of the main potential advantages of the DMA is that it is supposed to bring more speed to the whole process. But if the rules are modeled on competition law investigations, the reason, and we know that those investigations take many, many years, then I think it was quite obvious that when you put these into a essentially codified version of them, that will also require litigation. And that's probably going to take a long time to resolve as well, because the content is not self-executing. The content requires a lot of judgments to be made, assessments to be made, and there are, prohibitions, so proscriptive obligations opposed to prescriptive obligations, which means that somebody is going to have to monitor and assess whether the gatekeeper did not do what it was not supposed to do, as opposed to do what it was supposed to do. So for all these reasons, I think there are a lot of issues with the DMA. And like I say, as in terms of principle, I think there is need for regulation and for certain aspects of digital markets. Whether the DMA is the right type of regulation, I have my doubts, I guess.
On purely operational part of the juristic mechanism, does it give, in your view, the commission to the commission a lot of discretion and a lot of competences and power in terms of intervening at whenever it thinks it's necessary and asking from the designated gatekeepers, again, whatever it thinks is necessary for delivering fairness and contestability related outcomes to the market is, and also a second sub question, does the commission have this in mind, what it wants to deliver? Is it being divided like each core platform services for each designated undertaking, or it's again, it's something broader, more universal, pan-European? So the question consists of two, of technical side, of your evaluation of the juristic potential of this toolkit. Does it give the commission sufficient flexibility? And the second one, what should be the end game?
Yeah, I mean, I think it gives the commission a lot of power, and you know, the gatekeepers have all got their you know, compliance reports and so on, and the commission has not been shy of opening investigations pretty much as soon as, you know, those compliance reports came in. And I'm assuming the commission is also receiving complaints now from those other business parties that potentially these gatekeepers are not complying with all the rules, and the commission has been very quick in terms of opening investigations. But how long these will actually take so there is definitely the possibility to act quickly, but how long it will actually take for the matters to be resolved quickly, and whether they'll be resolved in a way in which we will see more competition. You know, if we look at it at the more macro level, whether these markets will open up or will become more contestable at a more macro level, I don't know if we are going to see that necessarily as a result of the DMA. I think the end game has to be about making the markets more contestable, more open, more competitive. But when the rules are really so much, not all of them, of course, but many of them are about, to a degree, it seems, sharing of the rents between the trading partners and gatekeepers. I think the fairness aspect is really about that inter partes fairness, really. I don't know how that necessarily translates into more contestable markets in itself, even if it can be enforced speedily. And of course, there's potential litigation that will go beyond this. So if we have a, you know, infringement finding, let's say, quite likely that will be litigated too. And then there will need to be a discussion about, well, you know, this obligation to not have discriminatory terms. Then you're going to have a whole, you know, assessment of what was, you know, reasonable and non-discriminatory and so on, which is not, you know, a straightforward obligation, which I think is therefore going to generate litigation. And that can be said for many of the obligations. So we haven't even really seen the litigation side of things yet.
So that would be another opportunity for us to look at the development of this new regime in a couple of years, perhaps. You also work in UK academia, and you take senior positions pretty much in one institution, in one university, but you've been also at the Center for Competition Policy at the University of East Anglia and Norwich Law School. So how do you see the situation in our field? Are we developing in the right way? Do you see some systemic challenges? How do you see the maturing of your colleagues, academics at Leeds Law School, and maybe some other reflections, not systematic, just maybe some interesting observations which you can share with us?
Sure. Do you mean competition law or more generally in?
Rather more generally.
Yeah. I think the UK probably has, I mean, the rankings say so, but I think from experience as well, I think the UK probably has some of the best universities in the world. I think we are quite fortunate to be academics in the UK in terms of what we can do and the resources available, the opportunities available. So there are many advantages, I think, to being an academic in the UK. And on the other hand, there's also a lot of reliance on the UK universities on sort of the international market for students, which of course poses various challenges on all of the universities, I think, in the UK in terms of, again, finances, and of course finances that affect the resources that the university members have. In general, I think in terms of sort of reflections on how things are, or how things were when I joined UK academia, which was now about 17 years ago, and comparing that to how it is now, I think the job market has become more competitive, and the standards for entry-level positions seem to be going higher and higher. And I'm not sure a lot of the PhD students, for example, who are coming out of PhDs to enter that job market are necessarily attuned to the requirements of the job market. So I think those of us who are in senior academic positions could perhaps do more in terms of giving advice and guidance to those more junior colleagues, especially those, I think, who are coming out of PhD to go into the job market, in terms of what will be needed to, get into the job, get a job and then to succeed in academia. So I sit on a lot of recruitment panels, both internally and also externally. And I think the awareness of the requirements of, getting that first job, what you need to have on your CV to get there, is not consistently robust. So I think those of us in senior roles should probably be doing more to make junior colleagues aware of what will be required in terms of becoming an academic if they want to do that in the UK. And of course, I mean, every country really seems to has its own written and unwritten rules anyway. So I'm assuming the advice for the UK may not apply to other parts of the world, but at least for the UK, the standards seem to have, I think, got higher and higher. And so the market is more competitive, which for us as, competition lawyers, it's a good thing to have competition. But for those, seeking to get their first academic role, I think it's a challenging exercise.
Absolutely, it's very, very informative. I think it tells a lot. I think in the profession of law, the situation of recommending to PhD students to think twice before continuing with academic trajectory of their career is not as turbulent in some other areas of humanities in particular, but these repercussions already sensed by some young junior colleagues as well.
Yeah, I think law is still an area where you can consider becoming an academic, and you will be able to sustain yourself, let's say.
We're recording this conversation in 2024.
Yes. Yeah.
And we have this tradition to close our conversation with asking for recommendations, particularly for competition students. So much is going on, and so many challenges / opportunities. Yeah, particularly when you're young, you see challenges as opportunities, and that's excellent. So how would you recommend, what would you recommend to do, and how maybe to do it, to those who eager to join the cluster of competition lawyers in the following years?
That's a very interesting question. Oddly enough, I'd probably advise them to learn another language if they're in the UK and, they're monolingual. I would, and they're young, I would, advise them to definitely learn a second language, probably French. But especially if they're interested in, European competition law, where the UK competition law is still very much really tied to, I would advise them to learn a second language, and the ability to actually, read judgments in another language and being able to compare it with another language. I think it's quite important. I would also probably advise them to participate in some of the many events being organized, be it online or in person. There is so much happening in competition law. First of all, it's quite difficult to actually, stay on top of the developments. Even if you're just working in that area, it's very difficult just on your own to stay on top. And second of all, I think networking is quite important. So, actively participating in events and showing up to events and taking an active role, playing an active role, be it, through attending seminars, conferences, or taking part in the various moot competitions that take place in competition law. I think all of those are quite important for building one's profile and giving them the language, the right language, to converse in, and the skills really to really go and succeed in any area. But I think for competition law, because there is so much happening all the time, there's a lot of material. A lot of it is, case law based, obviously. Making the most of really activities such as yours, for example, listening to series like this or taking part in many of the online or in-person events and making connections with people who are also in the same area would probably be quite useful.
Absolutely. Thank you very much. Pinar Akman, thank you very much for this very informative conversation. It's a pleasure to see you.
Thank you very much for having me, Liz. Thank you.